Good morning. This is Mary Hendricks from Jackson Kelly, and I'd like to welcome you to Session 3 of Jackson Kelly's webinar, Litigation in the Marcellus and Utica Shale Deposits. Before we get started, I'd like to take a few moments to address some administrative issues. Number one, we understand that we've committed to you to be done in a half an hour, so we will do that and would ask that any questions be held until the end of the presentation. If you do have a question, you can submit them at any time using the chat panel located at the bottom of your screen, or send them to marketing@jacksonkelly.com. If you have technical questions during the course of the webinar, again, use the chat pane or send an email to marketing@jacksonkelly.com. Finally, a web link with the recorded presentation will be sent to you in the next few days, along with a voluntary survey commenting on the program and asking for additional topics that you'd like to have covered. To make sure that there's no interference during the webinar, we've muted all participants' phones. And with that, today we'll be covering oil and gas law updates in Pennsylvania, which will be presented by Michael Leahey, an attorney in our Pittsburgh office. Mike?
Thank you, Mary. I was asked to put together some basic information on case law updates in Pennsylvania relative to the Marcellus shale deposits. And as we were going through and putting this together, what we found, and as soon as I can get my clicker to work, well, as we're trying to figure out our technology here, what we've titled this presentation is "Everything Old is New Again," and what that basically means is, although we're seeing more and more cases now involving the Marcellus shale and oil and gas related litigation, what we're really seeing is cases that are simply applying precedent that in many cases was established well over a century ago. To give you an idea of the precedent that we have, the Chartiers Block Coal versus Mellon case was decided in 1893. At that time, Justice Williams, in his opinion, estimated that by 1893 there were approximately 60,000 oil wells drilled in Pennsylvania. The average cost of those wells was approximately $240 million invested. Production of oil by that time had increased to approximately 110,000 barrels per day, and the total oil production by 1893 had eclipsed 560 million barrels. So although we have a lot of new litigation arising out of the Marcellus shale, these are issues that have been addressed by Pennsylvania courts and by Pennsylvania statute for well over 100 years. So the first area that I'd like to discuss involves surface rights. Where we start with surface rights is really back with the Chartiers Block Coal case in 1893. In that case, the court was addressing the rights of coal companies versus the rights of the owners of oil and gas, and trying to determine who had the preference to extract either the coal or the oil and gas. This case has direct application, though, to surface right owners and owners of various strata of the subsurface in the Marcellus-related cases that we're dealing with today. from the Chartiers case, Justice Williams stated that as a broad proposition, the several layers of strata composing the Earth's crust are by virtue of their order and arrangement subject to reciprocal servitudes. And these are imposed by the laws of nature and are indispensable to the preservation and enjoyment of the several layers. What this essentially means is the court recognized in 1893 that without the subsurface, the surface could not be supported for cultivation or residence, and the surface would become valueless. And it also recognized that without access through the surface, the subsurface mineral rights would themselves become useless. And so the court recognized at that time a necessity for there to be a cohabitation between the surface owners and the subsurface owners. So the seminal rule that comes from the Chartiers opinion essentially holds that as against the owner of the surface, each of several purchasers would have the right, without any express words of grant for that purpose, to go upon the surface to open a way by shaft, drift, well, to his underlying estate, and then to occupy so much of the surface beyond the limits of his shaft, drift, or well as may be necessary to operate his estate and remove the product thereof. So again, all the way back in 1893, the Pennsylvania Supreme Court recognized that for subsurface mineral rights to have any value, the grant of those rights had to come with a reciprocal grant to use the surface. Then in 1918, the Supreme Court again addressed the issue and held that as a general rule, when anything is granted, all the means of attaining it and the fruits of it are also granted. In short, when a grant is uncontrolled by words of restriction, all the powers pass which are required to obtain full enjoyment of the thing granted. What this case has done is set up essentially that a grant of subsurface mineral rights without restriction grants an access to the surface to extract those minerals. However, it also allows for certain restrictions to be placed on that grant such that the use of the surface be restricted in reasonable ways. So the first of kind of the modern era of cases on this issue that I want to discuss is Belden and Blake Corporation versus the Commonwealth of Pennsylvania. In this case, the Department of Conservation and Natural Resources, or DCNR, filed an injunction against Belden and Blake. And essentially what they said was, because they were statutorily mandated to preserve Commonwealth lands, and in this case state parks, it was reasonable and actually required of it that it put additional requirements on the use of the surface for purposes of extracting oil and gas. Although the court agreed that the argument of DCNR was a noble one, what the court ultimately held was that a subsurface owner's rights cannot be diminished simply because a surface comes to be owned by a government or any party with statutory obligations, regardless of the purpose of those obligations. What this case does not address is a lease with, for example, DCNR or any Commonwealth agency. If the land at the time that the lease is entered into is already under the control of DCNR or any other Commonwealth agency. Certainly they can impose whatever restrictions they would deem to be necessary to accomplish their goal. But in this case, what happened was these were lands that DCNR had acquired after the lease had been entered into. In this case, simply says that a subsequent owner of these state lands cannot then unilaterally impose restrictions which were not placed at the time of contracting. Again, this stands for the proposition that only those reservations and restrictions that are placed in the lease at the time of contracting will ultimately bind the subsurface owner in terms of how it can use the surface property. The next case I'd like to discuss is Humbertson versus Chevron. In this case, the plaintiffs, the Humbertsons, owned approximately 130 acres of land in Fayette County, Pennsylvania. Chevron was the ultimate party that had acquired the interest in the oil and gas underlying this property. And they began operations on the site. Part of those operations involved the construction of a freshwater impoundment that ultimately encompassed approximately 11 acres of the surface. The plaintiffs again moved for an injunction stating that the lease that they entered into with Chevron did not contemplate the construction of this impoundment. The factual progression of this case, the leasing clause contained within this lease did contain language that the subsurface mineral rights came together with such rights as may be necessary or convenient to produce the minerals underlying the surface. It also contained language that right was also present to extract and move minerals from leasehold interests on neighboring lands, and contained typical unitization and pooling language. The parties also entered into a surface damage agreement after the lease, whereby Chevron agreed to pay $10,000 for 7 acres of the surface, and then agreed to an additional $1,500 per acre payment to the extent that that area ultimately needed to be expanded. After all of those agreements were entered into, Chevron recognized that it would be convenient for it to place a freshwater impoundment on this property and moved to again enter a lease to place that impoundment. The owners did not agree to that lease, and it was never entered into, yet Chevron chose to construct that freshwater impoundment. When this case ultimately went to the Pennsylvania Superior Court, the court held that the owner has a right to enter and recover the natural gas, oil, and the gas lessee had the right to use the surface of lessor's property so far as was necessary to explore for, develop, and produce natural gas, and that included the construction of the freshwater impoundment. The court went back and quoted some older cases dealing with coal mining, where they held that the bare right to work carries with it the right to use so much of the surface as is reasonably necessary. A mine owner has the right to enter and take and hold possession even as against the owner of the soil, and to use the surface so far as may be necessary to carry on the work of mining, even to the exclusion of the owner of the soil. Ultimately, the court held that to produce the natural gas and maximize production from the Marcellus Shale, Chevron must utilize hydraulic fracturing of the seam of shale. Because the process required significant quantities of water, the temporary impoundment of water on the surface of the lease premises is reasonably necessary for the hydrofracking process and therefore is incident to the grant. Ultimately, the Pennsylvania Superior Court found that Chevron's right to the portion of the surface occupied by the impoundment was actually superior to that of the surface owner's right. Again, this is a good case that again shows that subsurface owners have to have reasonable access to the surface in order to retrieve the minerals from the subsurface. Otherwise, those subsurface minerals are worthless. Next, I'd like to talk about some contractual cases dealing with the obligations and the rights that come under these natural gas leases and related contract documents. The first case that I'm going to discuss is the Butler versus Charles Powers estate case. This is a recent 2013 case that deals with the characterization of natural gas. In this case, there was a deed that reserved half of the minerals in favor of the prior owner, and that was the Powers estate. The new owner moved to quiet title on not only the 1/2 interest that had been reserved, but also through an adverse possession theory, actually moved to quiet title on 100% of the 100% of the minerals. The Powers estate filed a deck action basically to request the court uphold its reservation of the 1/2 mineral rights interest. And at the same time, the current owners moved to quiet title on those mineral rights. The court went back and viewed this case in the light of the Dunham case, which was an 1882 case, which essentially held that natural gas was not a mineral and must be separately reserved from a general reservation of the mineral rights. The court came to that conclusion based on the fact that it used a non-scientific understanding of the nature of natural gas and oil and not a scientific method. As you may know, anybody who's played 20 Questions, there are basically 3 types of objects in the world. There are plants, there are animals, and there are minerals. Therefore, a mineral is anything other than a plant or an animal for purposes of the scientific community. But what the court did in 1882 was stating that in a private lease agreement, we're not going to hold someone to a scientific explanation of what a mineral is. And so what it did was basically held that minerals were only things that were classified as metallic or having properties of metals. And so typically things like iron, chrome, things along those lines were deemed to be minerals, and the court in Dunham held that natural gas and oil would not be considered minerals for purposes of a mineral reservation. When we move forward to the Butler case, what they held was that the Dunham rule that was set forth in 1882 still applies. That rule creates a rebuttable presumption that the word minerals was not intended to include natural gas or oil, absent a showing of compelling reasons of public policy or the imperative demands of justice. Now, what the intermediary court, the Pennsylvania Superior Court, did in this case, the trial court had granted the motion that held that the Dunham Rule applied and that oil and gas were not minerals. The Superior Court had remanded this back to the trial court to hold scientific, to take scientific testimony to determine whether, based on the passage of time, the definition of minerals had changed. But what the Pennsylvania Supreme Court held was, even if you would get scientific testimony to say differently, that would in fact violate the Dunham Rule, simply because the Dunham Rule held that this isn't to be a scientific determination. This is to be a determination of how lay persons view this. So one of the issues that's left open here is whether or not parole evidence could be used to tell the court that the intent of the parties was to reserve the oil and gas. I think that that's something not addressed by this court, and certainly would be a potential argument moving forward that may need to be addressed. The other thing that this doesn't do, the reservation also included language that it reserved the minerals and appurtenances thereto, and anything appertaining to the minerals. Ultimately, the court held that that argument was waived because it was not raised in the court below. Again, it's just something to keep in mind that while this Butler decision very clearly holds that the Dunham Rule still applies, it does leave open some potential avenues for attack moving forward. The next case deals with forfeiture clauses, and that's the McCausland case. In this case, plaintiff leased rights to the oil and gas underlying its property, and there were wells drilled on the property. The royalties for those wells were paid, and at some point in time the production ceased. Although the production ceased, as opposed to typical royalties, this was a flat, pardon me, let me read my writing here. Although the royalties were paid, the royalty payments eventually ceased, and the surface owner sought to both collect the back royalty payments and to enforce the forfeiture clause of the lease and void the lease. What the court in McCausland stated was that royalty-based leases are construed in a manner designed to promote the full and diligent development of the leasehold for the mutual benefit of both parties. As such, they held that ultimately you cannot recover the royalty payments and require a forfeiture because the acceptance of royalty payments essentially operates as a waiver of the right to then forfeit the lease. The court also went on to state that the forfeiture language in these types of leases is typically there to guarantee the production of the leasehold interest and is not there to guarantee payment. So again, once the wells have been drilled and are producing, the forfeiture clause should not typically be invoked. The next case is the Helsley case, and this involves the lease terms. This is essentially a case that deals with fixed rent payments versus royalty agreements. And in this case, a well was drilled on a property, and under the lease there was simply required a monthly flat fee rent as opposed to a royalty payment. Even after the well that was drilled had stopped producing, the company continued to pay that flat rent in hopes of continuing the lease. Ultimately, the court held that in a fixed rental payment lease, when those payments are only due during the time of production, the term of the lease will come to its natural end when the production ends. And simply continuing the flat rental payments will not in and of itself extend the term of a lease that would otherwise terminate because of lack of production. The Caldwell case is a recent case that deals with the implied covenant to develop the leasehold. In this case, the landowners entered into a lease agreement for subsurface rights, and the parties agreed that the company did in fact drill shallow wells and began recovering natural gas in paying quantities. The landowners argued, however, that there should be an implied duty to develop all of the strata underlying the property to the extent that it was economically feasible. So essentially what they wanted was to force the company to develop the Marcellus as opposed to what the landowners deemed to be minimally profitable shallow wells. The court ultimately recognized that this was a case of first impression, but ultimately held that there was no Pennsylvania law to require a company to develop each strata in order to fulfill its duty to the landowners. Ultimately, the court held that even if a shallow well is producing in paying quantities that is very minimally profitable, that is enough to satisfy the duty imposed on the companies to develop. I'd like to end with a few issues relating to some tort cases. And in Pennsylvania, we have a very strong workers' compensation statute that provides complete immunity for employers against suits by their employees. Unlike some other states, there is no workaround, and so it is a complete comp bar. A kind of additional benefit that comes with that is the Pennsylvania Workers' Compensation statute provides that a person who contracts with another to have work performed consisting of the removal, excavation, or drilling of soil, rock, or minerals shall be deemed to be a contractor. When you look at Section 461, a contractor can be deemed to be a statutory employer of a subcontractor's employee even when there is no direct employment relationship. This provision comes out of the state's worry that smaller subcontractors involved in the extraction of minerals may not fully comply with the Pennsylvania Workers' Compensation statute. As such, it places ultimate responsibility for the payment of the workers' comp benefits on the general contractor extracting those minerals. As the quid pro quo requires, that general contractor then also gets the benefit of the immunity even in cases where it is not required to pay the ultimate workers' compensation benefit. In 2012, the Pennsylvania Supreme Court in the 6L packing case indicated that neither the McDonald versus Levinson Steel Company case, which provided a test for determining statutory employer, nor the per se owner exclusion applies for purposes of 302A, which deals with the mineral rights owners. So again, that case simply strengthened our ability to use this to the benefit of companies engaged in the extraction of minerals to have immunity for these types of tort cases. The final point that I'll bring up is on indemnification. Within the oil and gas industry, I know that many companies use master service agreements and other contractual vehicles for indemnification purposes. In Pennsylvania, agreements to indemnify a party stemming from that party's sole negligence are disfavored. However, when very clearly identified in the contract document, those types of provisions are in fact upheld. I will say that those provisions do in fact need to be very specifically identified, and if anybody has questions on that, I would be more than happy to look at any contract language that you may have, and we can certainly compare that with the statutory requirements. The last point on indemnification, although the Pennsylvania Workers' Comp Act that we just talked about provides some great immunity provisions, it does provide a wrinkle when you're dealing with indemnity agreements. The workers' comp immunity not only protects employers against direct claims by their employees, but it also protects employers from third-party claims. So again, unless your indemnity language contains very specific provisions whereby the employer is going to waive their workers' comp immunity, your third-party contractual indemnification may in fact be held to be void. So again, just watch that language in PA and make sure that it's very clear that the party that you're contracting with is specifically and explicitly waiving its right to immunity under the workers' comp statute.
Great, thank you, Mike. We don't appear to have any questions today, so we will be concluding this session of our series. Please feel free to join us on January 9th, 2014, where we will have a look at what we perceive will be some issues in 2014 facing the oil and gas industry, and we will have our speakers from West Virginia, Ohio, and Pennsylvania available to answer your specific questions. Thank you.